Safe Harbour, a pact that helped the tech giants and others send personal data from the EU to the US, has been ruled invalid by the European Court of Justice. With me now to discuss what this means for business moving forwards is Cynthia O'Donoghue, a partner at Reed Smith. Cynthia, why did the European Court of Justice make this ruling?
It all stemmed from the Edward Snowden disclosures about the systematic monitoring and surveillance of people's communications. And so an Austrian student named Max Schrems asked the Irish Data Protection Authority to investigate that, and the authority said that they didn't have the power to, and so he sued in the Irish court, and the court referred the question to the European Court of Justice.
Well, the court said that Safe Harbour did not sufficiently protect EU citizens' personal data, as American companies were bound to disregard without limitation the privacy safeguards where they came into conflict with the national security, public interest and law enforcement requirements of the United States. Do you think this is accurate?
It is without limitation, and there's an inherent conflict of laws between Europe and the United States, and security concerns trump the privacy of citizens. There's a cultural difference here. In Europe, privacy is a fundamental human right, and in the United States, it's a consumer protection issue. That cultural difference is really at the heart of the court's ruling.
Safe Harbour was set up 15 years ago, so why has it been classified as invalid now?
People didn't realize there was the systematic monitoring of their communications until Snowden disclosed the information about it. And so there's been a general concern in Europe about what the US authorities have been looking at and the scope of what they've been looking at.
So who do you think is going to suffer most from this decision?
I think most companies will suffer, because if they are a multinational headquartered in the United States, they're likely to have certified to Safe Harbour themselves. And if they aren't, and are a company based here in the European Union or in the UK, they're likely to do business with a US company who is certified to Safe Harbour.
Well, this ruling really does create a lot of uncertainty for European and indeed international companies who have relied on Safe Harbour. So what are their options moving forwards?
They don't have a lot of options, to be honest. There's two key mechanisms that the European Commission has approved for transfers to countries like the United States. One is called the Model Clauses, which is a set of standard agreements, and the other is called binding corporate rules. And that is essentially a code of conduct that the data protection authorities review and approve. And that is quite a long process.
So how have the big tech giants such as Facebook responded to this?
Well, Facebook hasn't actually responded as of yet, but what we are seeing is companies looking to put in place something else. And I think the quickest response at this point is to put in place the model clauses. Some of the tech giants will have other avenues available to them, such as the contracts that they have with their individual users, but they will still have to apply the European data protection rules in the way they process those people's data.
You don't think they're going to just find another loophole to sort of get around this?
I don't think Safe Harbour was a loophole to begin with. I think the problem is our final understanding of the scope of the surveillance, which is what changed the game. I think we're going to see increased enforcement out of this. I think the data protection authorities on the back of the court's ruling will feel empowered to do more investigations, and we may even see more litigation from individuals.
So a revamped data transfer system, that's what everyone's looking at now. How far along with that are we?
We're not very far. The original Data Protection Directive is currently under negotiation before the European Parliament, and we expect the new document to be ratified sometime later this year or early 2016, and then companies will have 2 years to come into compliance with it. But the short-term answer is probably the model clause agreements, which are issued by the European Commission.
Do you think this is going to hit tech companies in terms of competition compared to other countries that don't have this issue?
It is an issue. I mean, obviously there's a bit of protectionism going on here, and certainly on the cases that we've worked on and the experience that we've seen, people are trying to be creative. I think it is likely to have economic impact, but I don't think that the case means that transfers of data to other countries are insurmountable. I think there are solutions.
So do you think similar pacts are going to suffer the same fate moving forwards?
I think it's the more scrutiny. So I think we will see increased enforcement actions. And so there's an onus on companies to make sure that they're not just entering into agreements, that they obviously have all the policies and the procedures and monitor the way they handle data in the future to make sure they are in compliance with the European requirements.